New Mexico Family Advocacy Program's 60-second echo session. The New Mexico Family Advocacy Program is a model of respondent parent representation being implemented in the 2nd, 13th, and 11th judicial districts. The program utilizes interdisciplinary teams of lawyers, social workers, and parent mentors that provide high-quality representation and the advocacy and support families in the child welfare system need for reunification or other preferred outcomes. I assume you all know, I'm going to go off script for a little bit here and just say that this is our final echo session. It's a little bit bittersweet, I think, for a lot of us. We began in March of 2019 doing these sessions. I just want to really quickly thank our colleagues that have so generously shared their time and expertise. All of you, our participants who asked really thoughtful questions of our presenters and shared your ideas and insights. I want to thank the Training and Education Committee, including those from CYFD, for sharing their time and ideas, seeking out presenters, and helping to prepare the sessions. Thanks to Kristen Conley and the Corinne Wolf Center for securing our CLE credits, and the Center of Innovation at New Mexico State University for securing our CEU credits. And especially also to Corey and Jen, whose behind the scenes work actually made these sessions possible. So I want to just thank you all. Our last NMFAP echo session. So I'm Leslie Jones. I'm facilitating today. We have IT support by Jen Vera. If you need any help from her, Jen will be posting things also in the chat for us. So today's topic is preparing your client to testify using a team approach. Our presenters are Barry Porter. Barry is a law graduate from the University of Hawaii. After brushing all the sand from his law books, he clerked for a Honolulu criminal court for a year, then in 1994 joined the Office of the Public Defender for the state of Hawaii. From 2000 to 2004, Barry led a, I'm going to mispronounce it, Barry, Kolohe, or mischievous group of lawyers at the Public Defender's Office for the islands of Maui, Lanai, and Molokai. In 2004, Barry got caught up in the land of enchantment and he joined the New Mexico Public Defender team. In 2010, he was named the Director of Training for the New Mexico Public Defender Department. In 2014, Barry left the Public Defender Office and opened his own law office with his super fab law partner, Susan Burgess-Farrell. The firm Burgess & Porter Law specializes in criminal defense, custody rights, and other constitutional rights issues in both state and federal court. Mr. Porter has served as legal counsel in over 100 jury trials. Susan Burgess-Farrell completed a Bachelor of Science in Social Work degree from Texas Tech University in 1982. She graduated from the University of New Hampshire Law School in 1990. After law school, she obtained a prestigious position with the Legal Aid Society of New York and began her practice of law in Manhattan, New York City, providing criminal defense to indigent clients. She continued her work in criminal defense in New Mexico, starting in 1997 with the New Mexico Public Defender Department. By 2014, Ms. Burgess-Farrell was the district defender or head boss for the entire Albuquerque metro area, supervising over 100 lawyers. In 2015, Ms. Burgess-Farrell partnered with her longtime colleague Barry Porter and opened Burgess & Porter Law. Primary focus of the law office is defending the constitutional rights of citizens in both criminal and civil courts. The guiding philosophy of Burgess & Porter Law is to provide assertive legal representation of the highest quality in order to bring forth a winning result for every client. Camille Hancock, LMSW, has over 27 years of child welfare experience, retiring from the New Mexico Children, Youth, and Families Department in November of 2019. While at CYFD, she began her career as a CPS investigator, leading to positions as a supervisor, manager, and finally as the Protective Services Division Training Director. As the training director, Camille was able to initiate the coaching program, assigning new employees with a regional coach to assist them getting started in their respective offices. After retiring, she joined the New Mexico Family Advocacy Program in April of 2020 as the lead social worker. Camille is committed to the advocacy for parents and children involved in the child welfare system and ensuring all voices are heard with the best possible outcomes for all. Queva Hubbard is a certified peer support specialist in the state of New Mexico. She currently works as the parent mentor coordinator for the New Mexico Family Advocacy Program in the 2nd, 11th, and 13th judicial districts. The NMFAP is an interdisciplinary legal representation program that focuses on providing parents whose children have been placed in state custody with extra support by partnering parent advocates with master's level social workers and respondent attorneys. Prior to NMFAP, Queva worked as a peer mentor at the Pavilions in Los Lunas, New Mexico, a therapeutic community for women coming out of incarceration, as a case manager at Crossroads for Women in Albuquerque. Queva uses her experience with incarceration, probation, and parole, addiction, and with being separated from her own children to help other parents make positive changes in their lives. She encourages growth, helps create stability, and provides assurance and hope in her community. Queva has advocated throughout the U.S. on multiple panels addressing topics such as social change in the child welfare system, mass incarceration, criminal justice reform, and interdisciplinary representation. Queva is currently the Vice President of the Board of Directors for Crossroads for Women and is currently a college student at New Mexico Highlands University pursuing a degree in social work. Queva's motto is, where there is support, there is less trauma. So thank you, our presenters, and I will turn it over now to Barry.
Hey, good afternoon, everybody. I hope everybody can hear me. First, I want to say thank you to Leslie and Corey and the whole team at NMFAP, because before this program, we had no teams. And we're going to be talking today about a team approach to direct examinations. And it has been really wonderful working with the social workers that we've worked with, both Susan and I. And it's also been really valuable program for our clients. And just want to give a shout out to everybody that, you know, we're each handed these like messes, and it's really admirable that people like yourselves are stepping up to take care of families in need here in New Mexico. So very grateful to have worked with all of you, and I'm sure we will continue to see each other in the future. So our task today was to talk about direct examination, and in the criminal defense world and in the abuse and neglect world, it's often neglected, but it can be very important. And I have found in my cases that when I've put my client up on the stand and done direct examination with my client, it's turned the case around on whether there was going to be a termination or an adjudication. So having extra people on hand, like I've had Louise and Kat and Queva helping with cases, meeting at clients' homes, it's really powerful stuff. So let's kind of talk a little bit about the basic bones and what our goals are for today, or rather the goals of cross-examination. And I'm going to ask that Camille and Queva, you guys jump in, and if it has to do with parents or social work, I'm going to take a back seat. Okay. One of the biggest things for me has always on direct exam has been humanizing our client, because the whole system is so dehumanizing, and the judge doesn't, you know, if they don't really think they're dealing with a human being, they're not going to take their decision making as serious, and they're not going to be as concerned and as invested in your client's case. So it's really just an opportunity for you to introduce your client to the court. Also, then the client has really valuable information. We want that relayed to the court. So you kind of want to build that connection, build that some sort of sense of intimacy between the client and the judge, which in abuse and neglect cases, they're the finders of fact. And then once you've developed that sense of some connection or relatability, then conveying all of the information in an impactful manner. We're going to cover how to develop and introduce evidence so that it can be put before the court, and kind of cover what the team does, the preparation on the social work side. And so I know Queva and Camille will be able to address that, and our preparation on the legal side, and how we prepare together as a team. And so we've got 5 steps outlined here that Camille and Queva and I worked on. And so we're going to kind of cover each of those. Let's see if I've got this. Yeah, so the social worker, maybe if Camille can kind of jump on here.
I gotcha.
I like where you even start. If you can back up to custody.
Yep, absolutely. So as social workers, we want to make sure we're discussing the process and what each hearing is, what it's about and the meaning behind each of those hearings to the client, so they have familiarity as to the importance of those different hearings. So the 10-day custody hearing, the adjudication, the termination, and making sure that we're doing it in language that they understand. As we move forward to the adjudication and termination proceedings, we want to make sure that we're gathering all the treatment materials. And what we mean by that is making sure that we know what has the client participated in, have they completed any programs, are there certificates, and what was the outcome of those treatment programs. We want to create, again, a list of those programs and providers, and then gather any key correspondence. So was there any monthly treatment reports that were written? Were there intakes that were completed, assessments that were done? Making sure that we get all of that in writing and have it available for the team to go over and look at. And so that's kind of just gathering all that paperwork and the things that the client has done. I think the biggest thing that we do as social workers is helping them make the connection. So it's not just that they went to a domestic violence class or they did a parenting class. What did they learn from it? So, in those conversations that we have with our clients, talking to them about, okay, so you did this parenting class. What were the 3 things that you felt were the most important that you learned from it? And getting the client to verbalize and say what those 3 things were, and then asking them to, okay, in the last visit or this over the past month, how do you think you've implemented that maybe consistency or being able to redirect? So having the client give you specific examples of how they integrated what they learned into the practice that they do with their children. And the more you do that, the more the client has the ability, when on the stand or when talking to CYFD, can say, it's not just that I attended this class, this is what I learned and this is what I'm doing. So it kind of puts that out that, these are the behavior changes. This is how I'm going to respond, even if they haven't had the physical ability to respond. I like to go over with clients, the what ifs. So let's say this happens. What are you going to do? To get them thinking, and then it helps them again create that narrative, so they're able to tell that story and they're able to share those examples and kind of prove that they have made these behavior changes, and that going forward this is what they're going to do. We like to check in a lot with our clients. I think we check in probably the most, along with the parent mentor, with clients prior to court hearings, just getting a pulse on how they're feeling. Are they anxious? What are they worried about? And then we can practice with them. So, if we know ahead of time, these are kind of the things that we know what CYFD is going to be asking if they are on the stand. How do we prepare them to answer that? So we can kind of do some trial runs, practice. Again, if you're having those conversations all along, it's easier for clients to remember and be able to talk about, these are the things that I've done, or these are the things that I've changed. And it comes second nature to them.
Thanks, Camille. Yeah, I think that's a key thing, that if the social worker can start developing those narratives of change, right? We were at this place when CYFD took custody, but now we're here and this is why, right? And so the more a client practices explaining that, the more comfortable they'll be in court when they're explaining it again. So that's great. Right.
And I think sometimes too, they don't see it. They don't see that change that they've made, or they don't make those connections, because it's kind of like, yeah, I heard it in class. And sometimes when you're parenting and you're just going and you're doing it, it feels like you're just going through the motions. but it helps put meaning behind those emotions. And, you know, as social workers, that's what we can draw on and help point out.
If I could say something to that as well,
Yeah.
Camille. Also, putting a name to some of the thought processes that the clients or the parents were having, and allowing them to see that there is a name for this, because it helps them develop the mindset that if there's an actual name, then there's an actual solution, right? Or there's some kind of support for it. So once they learn these things in group or IOP or parenting or whatever, and the name is attached to it, to me, I've seen the parents like get this aha moment to where they're like, okay, so I'm not the only person who has these kind of behaviors, or I'm not the only person who thinks like this. There's other people in this world who have this same mindset. And so if they have a name to it, then there's a solution. There's some kind of treatment plan, goal planning, or group that I can attend for some kind of support.
Perfect, Queva.
Yeah, and Queva, so, you know, this next slide talks a little bit about harm reduction. So, you know, helping a client develop a narrative, but also learning the vocabulary of healing. And one of the first thing here is harm reduction, right? So, you know, how would a client describe harm reduction? They would say, I'm a drug addict, right? But if you couch it in, no, I'm involved in a harm reduction medical management treatment program that, you know, and it kind of switches their brain about how they're thinking about themselves. And I'm wondering if anybody else has ideas about that vocabulary that you can kind of help parents develop. Anybody?
I don't see any hands or anything.
Okay.
Well, I would say you're definitely right, Barry. It becomes strength-based to use that kind of language for the client, you know, and for the client to use that language as well. It becomes like, oh, I'm trying, right?
Mm-hmm.
So definitely strength-based. Marianne? You're still muted, Marianne.
There you are. I think my client, well, I guess my question's for Mary and for the social workers and for you. So I've got this trial coming up. My client uses, but she's a good parent. So I offered Barry like $1 million to help me turn me down. So, this is sort of a new thought to me. Ever since I had a person that was a dyed-in-the-wool meth addict dismissed by the department, and it shouldn't have been. My case is very nuanced and quite different from that. Seriously, my client's a good parent. So I'm really struggling with what to do. Well, number one, getting her to show up, but how to offset that with the court. I mean, I'm going to have her testify. She's very persuasive and very bright, but using is really a problem for me. I've just been rethinking that.
Sounds like she's developed her own harm reduction system.
Yeah, she's been doing really good at it, but really well at it. I mean, but they're just after her regardless. And there really isn't any clear and convincing evidence that she hasn't done what she needed to do. She's just late all the time.
Yeah, and so Marianne, right, where you're going to be focusing on is, right, you're going to reframe it. It's harm reduction, and then is it a TPR that you're heading?
Oh, yeah, it's the second one.
Right. So
Andrea won the first one.
Awesome. And so, you know, what are the issues, right? Is it a behavior that's changed or likely to change? And, you know, usually I argue it's changed. And the statute doesn't say don't be a drug addict. It says, you know, have a safe place for your child and where they'll they'll be taken care of in a healthy way.
Well, that's the thing, right? She's got a house. It's okay. I think I can get rid of the using, but I just don't see the nexus between being late, and I mean chronic, and not being a good parent. But if you're going to meet somebody for a visit, right, like the department can't indulge. If you had a nanny, it'd be great. But I'm struggling. They really don't have anything. They just don't like her.
Yeah,
I
well,
mean, it's Sparta in there. I won't tell you who the other parties are, but it's Sparta for me.
okay, so let's see if Queva and Camille have anything to add, and then hopefully throughout the rest of this, there'll be some more tools. Thanks, Marianne.
I think in being not only harm reduction, but what are those relapse prevention plans, right? And what supports do they have in place should they feel like they want to use, or if they do use, then who can they pull in to take care of the children so the children are safe and taken care of in a proper way. It doesn't necessarily have to be her as the parent, but that's what the department is going to look for in regards to, okay, when you're using, then what's happening to the children? If you're the sole caretaker and you're using, if there was to be an accident, then how, does the parent have the capacity to call 911? Can they administer first aid? Can they drive them to urgent care under the influence? And so those are all the things that the parent would want to be able to talk about in, okay, if it's not me, then who is it? Who can I rely on? Who can co-parent with me? Who can work with me on this?
Great suggestion. Queva, how about you? And then if you can take us through the direct preparation for a parent mentor.
Yeah, Susan had her hand up. Do we want to her real quick?
First, I just want to check. Can you hear me? I'm having a problem with speakers. Can you hear me? Okay. I think I remember why my hand was up, and it was in reference to the issue of, well, I call myself a drug addict, and what am I supposed to? That's what I am, and I wanted to address that. So I think it's important for us to help our folks remember that they're way more than that, and they weren't always that. And I think being able to identify something else that they can say that they have done that they're good at. I mean, no one's born a drug addict. I mean, that's not necessarily true anymore, but that's a whole other story. In terms of what else, who am I? What else can I do? What else can I lead with besides I'm a drug addict? In terms of my own identity and what else I can deliver to my kids. So it's always going to be different, obviously, each person we work with, but I think that identification is something we need to interrupt and show them other things. Thanks.
So I want to kind of piggyback off of that. Definitely going back to what Barry has stated about strength-based language. Using the term I'm just a drug addict, that has a negative tone to it. And so there, I feel as though a client will use that as a negative way to kind of put themselves down, so that the expectation that I don't have to change, or this is who I am and I'm okay with it. But if we support the client in saying, no, you're a person who is currently using a substance, it has a whole different, okay, you know what I mean? And attach goals to it. That helps with them understanding that moving on, that there is harm reduction, right? We all have encountered our parents who, some of our parents who currently are using or has some kind of substance issue problem, right? And unfortunately, asking someone to stop, that it's not going to happen. I'm just putting it out there. It's not going to happen. If you tell them, do not do this, they're going to do it. And so, as a parent mentor, I've had conversations with a parent, prior to court saying, hey, I do know that like harm reduction, you go to the methadone clinic at this time, is there a way that we can support you in making sure that, you are being given a healthy dose? You are very aware of what's going on in court, or can we go ahead and go right after court and I give you a ride, you do what you need to do or whatever, so that they are aware. Or if they are using, get to their house early in the morning. I've done that. Get to their home early, kind of keep them busy. They may be a little irritated but just talking with them through it and also acknowledging the fact of how they're feeling. You know, as a person in long-term recovery, when someone acknowledges the fact that, you know, hey, see, you're a little irritated. I know this is kind of off your schedule or whatever. You know, what can we do to get your mind off the fact that, you know, your normal routine is to do X, Y, Z? How can I support you today just so we can stay clear-headed before court, you know, at 1 p.m.? Like, what can I do? And also looping in the social worker for clinical support, and also letting the attorney know that, hey, mom usually does her thing at 10 a.m. She's going to be irritated. Do not take it personal. You know what I mean? Ask questions and be clear on what you're saying and try not to talk at her. Which moves, I'm gonna go ahead and skip to the third one and go back to the privacy, which the parents needs to feel they are heard by their attorney. On many occasions, meeting with the parent, they'll say, I haven't talked to my attorney. Or when I talk to my attorney, they just want to give me an update. They don't ever want to listen to how I feel or my suggestions. And so definitely slowing the time before court so that the attorney can have an ear. And I don't mean just a 30-minute ear, some time out of their schedule to where they are giving this client, this parent, their undivided attention, and they are listening, even if it's something that cannot be used in court. Using that time to hear your client means so much, because then they feel like their representation is doing the best that they can for whatever their goals is. And even after listening, if you go back and say, hey, you know, unfortunately, that is not something we can ask for. That is not something I can do during this hearing, but I can definitely write it down and follow up on it, you know, in the FCM or whatever. That means more than just talking at the client or over talking the client, or you're just so in a rush to where you're not even listening to the client, period. That's I will say as a parent mentor, that is the most irritating, and I'm being completely transparent now, the most irritating thing to see a parent feel as though they're not being heard because they leave out heavier than what they came in, because now they feel as though their attorney is not on their side, CYFD is not on their side, they don't know the outcome of court, and they still have all these questions. And as their parent mentor, I don't have an answer.
And so that's what been's kind of nice about having the team is, you know, people will push, you know, Kat will say, oh no, this person, they really, you know, they need to come in and they need to explain what's going on at visitation, or, and you know, how can we relay to the court who a person is if we don't know them?
Right. And I think explaining the why, sometimes it may take a little bit more time to do that, you know, and I'm thinking moving forward where you're, you know, with OFRA, and it's going to look a little different. The team is going to look a little different, but just taking the time to say why, you know, why aren't you going to do this? Or why did you do it this way? And, you know, it could be strategy. It could be, you know, the attorney knows, you know, what the judge may perceive or how the judge would take it in that way. And so just taking the time to tell the client, this is why I didn't bring this up, especially if a client's really pushing, you know, say this, say this, say this, say this, and the attorney doesn't, but just telling the client why you didn't. And that helps build that faith and that hope in their attorney. Again, you know, so that way they understand if it is strategy or if it is, you know, this particular judge, and just explaining it. And I know it takes time, but it's really beneficial to the client to kind of know why you're doing or why you're not doing the things that you're doing.
That is very important. Thank you.
You're welcome.
So privacy also, where can we meet before, during court? That since COVID, everyone's in Zoom world. And, you know, to our parents that we are supporting, you know, they're hustling and bustling in the industries, they're at work, they're moms, they're uncles or whatever. But we also know that in the background, there's a lot going on and a lot of distractions. And so having that conversation with them, like, what does this look like for you tomorrow to attend court? And if you don't have somewhere where you could be attentive and you can, you know, be private and you can hear what's going on, like, where can I meet you? So you can have that focus. I've met a client at Burger King, and we tried it at Burger King. Did not work. First off, client was hungry. She was trying to order food. There was people walking by. So just definitely having that conversation of the privacy and why it's important that your client is given that privacy. Prepare for presence of the children at the hearing. That is a big one. Some of our parents haven't seen their kiddos in quite some time, and all of a sudden, the judge may ask the foster parent to place the kid on the screen, and then, mom or dad flips because they haven't seen their kiddo. So definitely asking them and doing a check-in on when is the last time that they've seen their kid, and supporting them through that, because we all know if outburst happens, it kind of disrupts the court. So making sure that you are aware of the last time they're seeing their children.
Thank you, Queva. That's great. Yeah, because they got to be ready for the emotion. That's definitely going to be part of court. I wanted to check in with Susan, my super fab law partner, and see if she had any other goals that she thought were important for direct exam.
And then Barry Sherry has her hand up after Susan goes.
Okay.
I don't really think so.
Your mute is on.
You would think after 3 years, right, that this wouldn't be an issue, but oh well. I think that one of the most important things for direct examination is to give our clients confidence, because many of them have spent their lives being beat down, and then going into a courtroom where everybody's kind of judging you and staring at you. I mean, I can't think of a more frightening experience, especially when they're judging you about being a parent, which is one of the most personal things you can be, and is a comment on you. So I think spending time and helping them gain confidence and in many ways gain their voice is one of the most important things. And then have our clients be real, because I find it most compelling when our clients are just really honest and let that emotion out and don't keep themselves so controlled. Thanks.
Thanks, Susan. And Sherry, you had something to share.
Yeah, and I'm kind of behind the gun here as far as I'm just a drug addict. If they've been through even just an assessment, they're a recovering drug addict. You emphasize that they're already taking steps to do it. And then the other thing, as far as helping them feel empowered, I guess, was what I was picking up on was, I like the IPP meetings that CYFD is trying to start, because it's hopefully parent based. They get to say who's on their team, and they start out with strong points in favor of the what this person is doing right before they ever talk about anything that might not be going right well. So I think that that's something we can seize on, all of us. And then I really wanted to hear what Queva had to say about parents needing to feel that they're being heard by their attorney, because my ears perked up. Oh, am I missing something here? And so is the parent mentor able to talk with the client in other times about, are you being able to talk to your attorney about things? And then can they give that feedback back to the attorney to, okay, the next time you talk with her, maybe you want to ask her about this or emphasize this to help her feel like she's being heard, or he. Is that part of parent mentors helping with direct preparation?
Definitely. I know that Catherine and myself, we definitely staff those kind of things a lot. Like, are we having those conversations with our parents as far as when the last time that they have heard from their attorney and their feelings, and also, looping the attorney in. But that still doesn't hold any weight, unfortunately, because we're just the middleman, right? It really is the connection between the attorney and the parent that holds the weight, because, just to have this person to say this to this person, but this person is still not talking to me, that doesn't mean anything when it comes to court. That doesn't mean anything when it comes to building confidence and to know that, you know, your attorney actually is there for your best interest, you know. So I mean, I definitely think that is important for us as parent mentors to kind of mediate between the two, but it is solely up to the attorney and the parent to build a relationship so that that parent has confidence that they are being represented the best of their interest.
But you're saying that you would give me the heads up that I need to address this issue because she's not feeling heard or he's not feeling, I understand him. Right?
Oh, most definitely.
Okay, good. All right. Because that's me. I'm definitely going to put that into practice.
Yeah, what I've really liked is when somebody from the NMFAP program has facilitated an appointment at the office. And, you know, because face-to-face is just so much more valuable. And so when we all get together, rather than, you know, we're having different lines of communication, let's all meet, let's all communicate together. I think this is what I found is most valuable. Okay, I know I have a lot of slides to cover, so let's jump to attorney preparation. So this is just something that attorneys want to do. You want to discuss the legal burdens and the evidence, gather evidence to back up the direct examination because you want your client or whoever you're having on direct exam, you want their evidence corroborated or their testimony corroborated. And then you got to create a direct exam guide outline, and we'll cover some of that furthermore. And then discuss the process so that the client or whoever you're going to do a direct exam of understands, okay, this is what we're proving at this hearing. This is what CYFD has to approve. This is what our defense is. And I'll cover that kind of hitting the elements of the different types of hearings, adversarial hearings that we deal with in abuse and neglect cases. So the team preparation steps, we've kind of broken it down into 5: meeting, support, develop, review, and practice, right? And this all takes time. And attorneys don't have a lot of time, but you know, if you don't have a lot of time, you have too many cases. So have less cases so that you can do your clients right. So meeting, at the meeting with the client, and this is great if it's all of us, right? Because everybody has input. Review the burdens. So who has the burden? Okay, CYFD has the burden of proof. They have to prove at an adjudication by clear and convincing evidence to the judge one of these elements. Or at a TPR, they have to prove by clear and convincing evidence. Or if it's an ICWA case, beyond a reasonable doubt, that the causes and conditions that brought the child into custody haven't changed or are not likely to change in the foreseeable future. So, because if you explain the burdens to whoever's going to be doing the direct exam, they're informed about, oh, this is why he's asking me these questions. This is where he wants me to go, he or she wants me to go. Also at the meeting, you're going to get all the information, talk about what needs to happen, what kind of witnesses maybe can corroborate what your client's going to say. So that would be treatment providers are awesome witnesses, or other people that are present at the visitation. All different kinds of evidence. I've been having a lot of clients lately take videos of their visits because CYFD will come up with, you know, the bond is disintegrated and things like that. Well, a video speaks a lot strongly. Review the reports with the client, pull out the positive stuff. So that's step 1. Camille or Queva, if you guys have, or Susan, anything to add to that? Meeting in preparation for a hearing.
I think this just goes over that practicing, right? What, you know, just from the provider reports, but not just the provider reports, but that conversation with the client in regards to what are those things that you have been doing? What did you learn? What's changed? Again, giving the client the practice to be able to report that.
Yeah, absolutely. Well, and then like Queva mentioned, then you start maybe developing the vocabulary you're going to use at the hearing. You know, how you're going to frame things. And framing is everything in court. It's amazing how you can frame something. I mean, we see it political spin every day on the news, right? You can frame really bad things in positive lights. Reach for the positive, like some of you other folks have talked about. Support. So this is frankly not my, I don't know, it can't be my strong suit, but when you have a social worker there, and you have a parent mentor there, it really lets me focus on evidence, burdens, things like that. So maybe Camille and Queva can talk about support.
Right. So again, just making sure you're checking in with the client in regards to how are they feeling? What are they anxious about? What are they most worried about? What have they heard in regards to, CYFD home visits, or, what has the CYFD worker been telling them? And, reviewing all of that with them. I think we do, social workers and parent mentors do that aside from the attorney, but it's also important for the attorney to ask those questions and be part of that support and that check-in. So then that way, again, it creates that relationship with the attorney and the rest of the team. And then what coping skills do they have, and what have they developed? And then making sure that the attorney knows either through the parent mentor and the social worker, or through the parent, just making sure that the attorney is brought up to speed as well with any information. Has there been any missed visits, any UAs that maybe have come in that may be positive, or has there been missed counseling sessions, all of those things that could come into play. It's a good chance, a good time to get that information in, especially if it's might be negative or could be used negatively. Because maybe, again, there is that reason, I had to miss the parenting group this night because CYFD put my visit an hour before it. And by the time I got out of my visit and back home, or, there may be reasons why, and it's not just excuses, but there might be something more to why things were missed.
If I could jump in here, with the support, I'm gonna go back to the relationship with the parent and the attorney. I do feel as though that's a team approach. If the attorney has a great, not just perfect or whatever, but a relationship with the parent, when there is some fears and some emotions that may be regulated during a court hearing, definitely when it's in person, the attorney is the only person that can call for, some kind of break. Like, we can't, as a social worker, not as a social worker, but social workers or parent mentors, we can't say that, but we can communicate that to the attorney. But I've seen it firsthand where the attorney was very aware of the parent's emotions and instantly went to the group chat. And all three of us supported that parent until the judge called a recess. And so I think that goes back to the team approach and making sure that communication is being had prior to court. What are some red flags? What am I looking for as the attorney sitting here? Because I'm also, standing up for your defense, but at the same time, I, as the attorney, would need to read the room and read the client as well. Because if the social worker's deep, and I've seen social workers deep in clinical books going through it during a court hearing, to where they're not able to read it, but I can read it. I'm trying to text, but you're talking like it's a lot going on. But I do feel as though if that team goes in as one, that parent is definitely well supported throughout that hearing.
Yeah, and I love getting texts during hearings from the social worker. It's kind of reminding me of things to bring up. And it's a little bit tougher in court when you're on the record, to be looking at your phone. And I also, Susan and I do this all the time. We just walk up to each other. We want to, hey, here's a direct question that you forgot. We just walk up to each other, and other people can walk up to us too and remind us, hey, don't forget to hit, the parenting class that they attended.
Or have a pad of stickies and pass over the sticky note to
Exactly.
to the attorney.
That is a major tool.
Yeah, so make sure that's part of your little lawyer bag there, is having stickies.
Exactly. I carry
Susan, you had your hand up.
Yeah, well, what I was going to say is that what I have found is clients often want to look their best to their lawyers, and looking the best to your lawyer doesn't really help us. We really need to fully understand everything that goes on with them. And so it's almost like, you don't have to CYFD, they want to present themselves as, you know, they're doing everything. But when we're going into a hearing, we need to know the truth, not just what they would like it to appear to be. And so having those meetings with the parent mentor and the social workers to help us have a really clear picture of what's really going on is, I find, really, really helpful. Because there have been times, this has happened with Queva. I've met with the client and I thought, oh, everything's going great. And then the client left and Queva would say, well, the real story is XYZ. Right. And so it's really helpful if you have those team meetings and help the clients understand that we really need to know the truth and that there's no judgment. We're here to help. And how can we support you? And then, of course, as Barry said, how can we present it in the most positive light?
Great. Thanks, Susan. So that was meeting, support, and now we're on develop. And so this is the developing the evidence that you want to present during the direct examination of that witness. And I love it when a lawyer says, oh, I just wing it. I'm like, I want to smack them. You cannot wing anything and do it effectively. You must at least do an outline of a direct exam and review that with your client. Ideally, you send them that. I am kind of nuts is I have a bunch of templates for direct exams, and one of those has been provided for the materials today. Just kind of hits, okay, well, you know, what happened in custody? What happened, you know, how are the children before? How are the children after custody? What are the steps that you took? And so those are part of the materials so that you at least have a good idea of what you want to hit. And then you customize it for every case. And you gather these, what I call topics or chapters in the witness's examination. So you actually, and juries love this, finders of fact, judges love this, is you name, hey, this is the next place I'm heading. So as it starts, let me kind of jump to this first slide. Is the first topic I want to discuss with you is you, right? Introduce yourself to the court. Tell us a little bit about your upbringing, you know, and so you go through that topic thoroughly and bring out anything that supports your defense of the elements or that particular issue, TPR adjudication. And then you say, okay, thank you, you know, Mr. Johnson. The next topic I want to talk to you about is relationships. And you're actually taking time to let that finder of fact know I'm switching subjects here. And now we're heading into another thing that's entitled relationships. And the judges, juries come up to me after trial and say, you know, I just really loved how I understood that there was little chunks of information about different areas that you were bringing me. Super important in cross, but I think even more important in direct. When you really want this human being to be understood by the judge, by the court. Other topics, condition of the children before custody. Talk about all these different things. These are in the handouts. Other topics, the next topic is treatment plan and progress that you've made. Your response to the safety issues that got brought out in the affidavit that brought your children into custody. So did you do the assessment? What about psychological? How about family time? So each of these is a separate topic to review with the client, or if it's a family member who's been watching this, or if it's a treatment provider who's been watching somebody going through treatment. So the first thing I want to talk to you about is, you know, what was your first meeting like with Mrs. Johnson? Okay. And then the treatment progress. Let's talk about the next topic. How was the treatment? And then what have you seen as the next topic? I want to talk of changes that you've seen in Miss Johnson as far as how she cares for her children. So it's just super organized. That's like half the battle when you're presenting to the court.
Barry, there's a question in the chat. It's how do you handle relevancy objections reference the background topic?
You just say, Your Honor, this is, you know, you go to the burden of proof and you go to whatever the standard is so if it's a TPR, it has to do with whether the causes and conditions have been changed. And so I want the court to know where my client started, right? And so in order for you to know where they started, you need to know a little bit about their background so that the court, the finder of fact here, has an appreciation of the changes that have been made. I've never really, you just kind of argue things like that. And I've never really had much as far as successful objections to getting evidence in. Okay, so team preparation. And this really is much better if you have a meeting at our office or wherever. You know, it can be a Burger King if that's where it has to be. I like meeting at clients' houses if I have the time, just because that's their comfortable setting, and review that outline with them. And so, like Camille was mentioning, you're practicing, right? All along, you've been talking about what you've been doing. So now we're formalizing it. Here are the topics I'm going to talk to you about, and here are the questions I'm going to ask. And so you have not just you there, but you have these other team members who can chime in and say, oh, wait, you're forgetting about, you know, the parenting course that you took, or that your individual counseling addresses domestic violence. And then finalizing the evidence for the client, I give them a copy of their direct. It's usually 10, 15 pages. These are the questions I'm going to ask you. I want you to really review this. Hey, Camille, can you review this with the client, you know, the day before? Make sure that they're still on board with all of these answers. If something different comes up, can you let me know? And then I tell the client, don't bring this outline to court, but these are the things I'm going to cover with you.
Barry, I think everyone, at least the attorneys, understand why you can't bring that outline to court. But again, going back to the why, can you talk about why you can't?
Well, a client can't refer to something while they're testifying, right? Or anybody, a treatment provider, can't refer to their report while they're testifying because they're supposed to testify as to their current memory. So what they remember about the case. Then if we have to, we do this rigmarole, refreshing recollection, where we're shown their report in children's court. It's usually more relaxed. So sometimes if it's a treatment provider, they can have their report in front of them and testify off the report. But clients are generally not allowed to take notes up there. And then I don't like them to bring it because I don't want them to get cross-examined about, you know, when the children's court attorney sees it, it says, oh, you practiced all these answers, right? You practiced all this with your lawyer. And so ideally, you know, I just say, leave it in the car. Just don't bring it into court.
There you go. Thank you. That just helps with the why, because sometimes I think as social workers or parent mentors, we get asked like, why can't we? And we're like, oh, I don't know, the attorney said. But it just helps put that language, you know, towards that. And again, you know, as you're talking to your clients, just moving forward, because OFRA is going to look a little different, you know, how do you explain that to your client if they say, well, why? Well, why?
Yeah.
Sherry, you have your hand up, and we have hit the 1 o'clock mark. So I know that some of you are going to have to jump off, and that's okay. If you could fill out the post survey questionnaire, and then if you are requesting CEUs, remember to send that to the ECHO. And then Jen has put the attorney's CLE thing in the chat box as well. And Sherry, do you have a question?
Well, I was just about ready to lower my hand because I realized that my question was about preparing other witnesses, not the client. So it's
Gotcha.
Not really apropos to this, but I'll tell you right now, this sort of training could be all day long. This is important stuff.
Yep.
So please do it again.
Yeah, and it's important, Sherry, for and professional witnesses, treatment providers. God, they just hate it when lawyers don't prep them for their testimony. You must send them an outline of what you're going to ask them about. And really there should be a conversation, this is why I'm calling you, this is what I have to prove, or this is what we're rebutting from CYFD. So that preparation is key. These are just some of the things that we use to explain the law. So a TPR law, some people are verbal learners, some people are visual learners. Boy, if you provide them something in writing that they can take home and really understand the law a little bit more, and you go over it with them, we just find these invaluable, and everybody is free to use them, copy them, we don't care. Then this is another really big point that just kills us because of time, right? It takes time to do this. But if you can practice with the witness, the questions you're going to ask and the answers they're going to give, it's invaluable. And then on top of that, as Susan will tell you, right, is practice the cross exam, right? What is the children's court attorney going to say? What is that nasty GAL going to say to you? And then, it's funny on video stuff, right? When our clients testifying, I'm like, no, listen, I'm very impatient. Set your phone down. It needs to be in a stationary place. You need to be dressed like you're in court. You need to have something decent on. There better not be anybody running around. Just, try and really present yourself well, so you're conveying to the court, hey, I'm really invested in getting this information to you. And then in court, I just have a uniform for guys that they just have to wear during trial, and women, generally, that's not an issue. So
I think that's the big thing, especially, in the COVID era is, where are they when they're appearing for court? Are they at McDonald's, or are they at, Starbucks, or are they in a room full of a bunch of other people and kids, and just being aware of, and if you have to show them ahead of time on how to blur out your screen behind you, that could be helpful as well, or even just turning on your camera. I know that's a big one for some of my clients, is just getting them to turn on the camera, and when they do, what are they wearing and what do they look like? Are they slouching and kicking back at the on the couch, or so getting them to really think about, yes, you're just talking to your phone physically, but the importance of the hearing, and the importance in how you're presenting yourself. And, everyone's going to see what you're wearing or what your background is. What's happening. Again, just pretend you're like in court, have that appearance. And then Shasta had a comment. There was a little chuckle of that. And so she says, maybe don't call them nasty GALs to the client.
And another thing, if it works, you'll know, you can tell the client, hey, would you do that if you were being interviewed for a job? Make it like you're wanting this job and you want to look your best and present well, so that they'll hire you, or in this case, they'll believe you.
Yeah, and then preparing a client to testify, right? Because if they've never taken the stand, it's a very intimidating process. So, if you have the time, you say, hey, go sit up on the witness stand, come up with me. So this is where the judge will have you stand. This is where you're going to raise your right hand. The judge will say this. See this microphone, you want to speak into it, and make sure everybody hears you. Hey, I'm going to ask you a bunch of questions, but if I miss anything, I'm going to ask you a question at the end, if there's anything else you want to say to the court. And what I tell clients all the time when they testify is, court is just a formal, very fake situation. So you talk to Judge Ward like you're talking to somebody at a barbecue about this whole CYFD situation. And, that's all you're doing. She's just a normal person. She goes to barbecues, and you're just explaining how the situation happened and what you've done to put things back in place, minus the swear words you might use at a barbecue. On the mock exam too, maybe think, okay, brainstorm with the whole team. What's the worst thing CYFD is going to ask about? What's the, that you just had a positive drug test, whatever, 4 weeks ago. right? So they're going to ask about it. We should ask about it first. We need to neutralize that on direct exam. And so it takes the wind out of their sails when they do cross-exam. So the worst facts you actually want to bring out in your direct exam so that you can frame the narrative, you can frame the vocabulary, and give it the spin that you want to for your client. Camille or Queva?
I think I've said everything.
Me too.
And then this kind of follows up with something that Susan said, is court is theater. You know, it is a show to a degree. And what Susan brought out is, you know, you want your client to be real, to convey their feelings when they see their children on the video that they've brought and that we're putting into evidence. You know, they get to share those emotions. They get to be emotional. And then, of course, conveying the evidence, putting it out there. If you've lined everything up in topics, then you go through on your argument and you've just basically got these topics that you went through each witness with on direct exam, brought out all the positive things that show your client has made changes or is likely to continue to make changes in the foreseeable future. And then this is another interesting thing that just kind of, I like lawyers to keep in mind. When we're closing a case, doing closing argument, the court, any finder of fact needs two reasons to find for you. One is legal, right? And so you got to find that hook in the law that, you know, where there isn't clear and convincing evidence. But the other one is the moral reason of why it's the right thing to do, to deny the government's adjudication or deny the TPR. And frankly, sometimes it's just sort of begging and speaking from a moral place of what's fair. So stepping outside of the law. The moral and a legal reason. And lastly, when you have a witness up on direct, give them the opportunity. Hey, I covered these topics. Is there anything else that you wanted to share with Judge Begay? And then also, I forgot this, is ideally you're training your client that this testimony that's a formal name for conversation. You're going to have a conversation with me and the judge. And more, I really want you to convey your information to the judge. So talk to her. She's a crazy nice lady, right? It doesn't seem like it, but she is, right? Or, you know, she's wearing black, but she's a very nice person. And she wants to hear why she should, you know, deny this TPR. She wants to hear it, but the only, you know, person she can hear it from is you, treatment providers, your witnesses. And let's see here. So some of the resources that we've compiled for you are the direct examination templates. If anybody ever needs one, you want the Word copy of it, I think we've provided them. The abuse and neglect case flow sheet, so that when you're explaining to client, here's the burden, here's the elements, they're all just written. Office of Family Representation, I guess I'll give my pitch here that just like the public defender's office or any major law firm, you got to have a library, got to have a electronic library of resources. So we've got the one, you know, at the law school already started. The abuse and neglect case manuals, good resources, and of course, your colleagues. I don't have anything else to say. Yay.
The forms that you said, are they in the
I think
training resources?
Leslie's going to send them out.
Well, they're in the NMFAP, the resource library.
Oh,
So if you, I don't have the link right with me, but maybe Corey or Jen, you have it. But if you go to
that's fine.
the NMFAP webpage, and then it has the echo sessions, and then it has the resource library there.
That's fine.
And all of the materials will be there.
Thank you.
Leslie, is Oprah gonna have a
Is-
library?
Yes, and OFRA absolutely will have a library, both physical and electronic. So we are working on pulling that together right now.
So Ofra is going to inherit NMFAP's library.
No, well, yes, I mean, we will make sure that everything that is been put in NMFAP's resource library will be still available. We don't know yet whether it'll just be a link to that or we're going to have to migrate that over to our website. We don't know yet, but we absolutely will keep all of those materials available for everyone, for sure. Marianne, did you have a question about that or?
No, I just want to say, it's really nice every time Barry and Susan talk, I kind of get re-inspired to press on.
I
And
agree.
keep retrying or honing my skills. I think I'm about in middle school now, so that's good.
No, they are.
But I just can't tell you, that is that's just the reflection of a true artist. That's what inspires me. So I mean, I say it all the time, but I think people should know these things while they're alive.
But we have to inspire each other because this is hard work, right? And I really want to give a shout out to social workers because my fabulous law partner was a social worker before she became a lawyer. And she kind of still is.
I didn't know you had that in your closet, Susan.
It never goes away.
So if there aren't any other substantive questions, I just want to thank everybody. A reminder to please fill out the survey for the session. Also remember to apply if you are going to apply for CEU credits or CLE credits. I think Jen has posted that information as well in the chats. Make sure that you take a look and follow those links to apply for those. And as I said, this is our last session. So we want to wish everybody the best of luck and